This is your teacher, Dr. Osama, and this is the second lecture. Today is Tuesday. This is the second lecture in our own business law. So we'll go directly to share the screen to talk about our topic today. We are going to complete about the law and the tort law and all regarding our work. So let me quickly remind you with what we stopped on the last lecture. We talk about the types of law, like as example, we talk about the law and its importance in the society in the last lecture. The law and its importance in the society, and that the law regulate the life of people. And the law provides the regulation rules, and law helps the people to achieve stability in the society, And then we move into talk about example about the PP, the PIPEDA, and this is the Personal Information Protection and Electronic Documents, PIPEDA. And we said it's very important for the private or to protect the use of the personal information, like as example, your SIN card number, your credit card number, your bank information, like your bank account number or whatever. Those all are very important and protected by the PPDA as well. And you write consent whenever you go to work, that you give this with your own personal information, with your voluntary or with your willing, and that also from the other hand, that the receiver of this information will use it, will not misuse it, and he will use it only for your benefit. That's it, and not against you. He won't get advantage of using your own personal information. And we said the names is excluded from the personal information, where the address, the telephone number, all of those is not, those are exceptions from the personal information. Personal information is very important for you to be hired to work, so you have to give this information to your own sponsor or to your own employer or prospective employer. But he has also to keep this information safe and not to misuse it, or take your credit card as example number and buy with it from the internet, or take your SIN card number and do mortgage with it. Like, okay, no, he has to use it only for the purpose which he collect this information from you regarding it. We talk about the business law and the definition of the business law before, and we talk about the business ethics and the law. And we said there is a trade line between them. You cannot see it. Business law and the ethics are almost very related to each other, because business law is built upon what we ought to do and what we ought not to do. For that reason, it must be incompatible with the business ethics. So the business law must be compatible with the business ethics. Then we moved on to some ethical decisions, like examples for some ethical decisions, and we moved after this to the types of law. We talk about the public law, we said, that regulate the relationship between one person and the society. How about the private law? The private law regulate the relationship between the business and business, or a person, individual, and another individual. So this is about the private law. Then we moved into the criminal law after this, and we talk about the criminal law, and we said, like, all the Canadians respect the Criminal Code of Canada, and this is a federal, not even provincial or municipal. And we will know what the meaning of federal, federal is on the whole Canada. Provincial, as example, like Ontario Acts, it's for each province of the provinces of Canada. This is provincial. About the municipal, it's about the cities, like the city of Toronto, and they regulate, as example, the traffic of the city of Toronto, using the parkings in the city of Toronto, using service areas or whatever, how all these are arranged by the municipal law, by law municipal, we say, by law municipal. We said the examples for the criminal law, like money laundering, tax evasion, identity theft, bankruptcy, all this, like, okay. Then we moved into the constitutional law and we said where there is a government, people, land, there must be constitutional law. This is a prerequisite for a country. A country without constitution is not a country. Constitution is telling in basics, the basics of the life in this country and how will be the relationship. How will be the figure of the government? How be the relationship between the people and each other? How be the relationship between the government and the people? How the society will be regulated? How far this government will respect the human rights, the right of choice, the right for elections. All this is guaranteed and protected by the constitutional law. We moved at the end of the lecture, the past lecture, to talk about the administrative law and to understand what do we mean by the administrative law. So the administrative law is that because it works on the levels of municipal, provincial, federal, and perhaps international as well. Example, the use of this law is for the disputes which happen regarding invoices and global transactions nowadays. This was about these kinds of laws. We move also, we said, in Canada as a country with a business that is doing a business, we do business here. So we move also to the tax law, and we said, due to the high volume of transactions and due to the importance of tax for the Canadian government, so there is tax law and there are tax courts as well, separated. It's only looking in the issues of the taxes. Okay, so this, and also those in this tax law courts, they're talking about the court relate to tax goods, tax income or income tax, goods and services tax, and employment insurance. These are the main topics which are handled in the courts of the tax courts. We'll go to see some points, like those points before we'll handle here. We'll watch a video, small video about each kind of them. That will make it easier for us for understanding, and it makes enhance the knowledge of us about the first one we'll see is about the business law. The business law will take a small definition about what is the business law in Canada, and we'll see a video about the business law in Canada. We need a small one. Let us see this one. I hope it will be short, not long, and at the same time, it might give us what we need.
My name is Dr. Ryan Clements, and I am an assistant professor and chair in business law and regulation at the University of Calgary Faculty of Law. My area of scholarship and research is in financial market regulation, particularly with an emphasis on financial innovation, how innovations in financial markets, products, and services can lead to benefits for society, and in some cases the risks that emerge when innovation is brought into finance. One particular study that I've been working for several years now is the role that technology and innovation education can have in providing greater financial inclusion in society. This type of study that I've been doing is transdisciplinary, that it looks
Like you see from this video, how far it's related. There is a relationship between the business law and all matters related to life. I will go only now also for a definition and a discussion about the video of a business law. I just want the foundation of business law in Canada. This one might be nice and it's short as well. We don't want long ones, that's fine. We'll see this. We need a video. We need to watch a video about the Canadian business law. Canadian business law. The Canadian business law. Again, Canadian business law. Okay. Here we go. And I wish we get a video about this videos. Here we go. Let's check out for a video about Canadian business law. Check for someone which is not so long, and also give us a full a full description about what we talk about in the last lecture can be summed up, and to remind us with the main points which we need to know.
Hello, it's William Chow, and this is Canadian Legal System, Module 1A, Part A. In this part, I will give you a brief introduction to law by looking at what is law, examining the differences between the two legal systems that we have in Canada, the common law system and the civil law system, examining the difference between a public law versus a private law, and then looking at the different sources of law that we have in Canada.
Those points we have covered enough. So I will leave this now, the videos, actually, because I don't see anything more than what we talk about, and we'll move to our next kinds or next types. As I see, those are very long videos, and it takes time for us, and we don't need to waste the time in just videos. So we will go now to our own work. So that's what we said before about the laws and what are each one of them. We talked in the previous lecture about the administrative law, and we said disputes regarding an example regarding the invoice. So in global transactions, this also is done or seen by the administrative law, or a matter of the administrative law. Tax law. What about the tax law? We said the tax law is very common in Canada as well. Civil law. Now, this is considered the start of our lecture today. The civil law. What is the civil law? Private civil law deals with disputes between individuals where one party has been harmed or injured and is seeking compensation. An example of this would be a slip of a fall outside of a business. Okay, I'm working, and while I'm working, my hand was cut or I have been damaged. This is the area or the span of the civil law. Civil or private law is also called tort law. So the civil law, we call it sometimes court law, court law. Okay, here this figure will show us the differences between the civil law. Let me enlarge it. Then I will return it back to the way it was. It can show us the differences between the civil law and the criminal law. A small glance here will show you the following. So once you look here, you see there are differences between the criminal law and the civil law. On the criminal law, we find criminal cases, but in the civil law, we find civil cases. In the criminal, the person is accusing or accused with breaking the law. This is in the criminal, accused of breaking the law. But in the civil law, two individuals, like we said, it's a problem of two individuals or group together come to an agreement in the civil law. The criminal is a problem. The criminal of a serious is very, very serious. This is the criminal one. It is a very, very serious because it includes a lot of problems, a very breaching to the society and dangerous for the whole society. It's like theft or doing works like robbery or trafficking. So all those are works also like all those types of works are breaching the society and breaching the privacy of the whole society and breaching the safe of the society. While the civil law, as example, we'll see like the injuries, the contracts, the divorce, the will, when you write your own personal will. So this is a matter of a civil law. So we have criminal law, like we said, like you see here, it is a problem between the person and the society. It is symbolized here by the crown. But here it's between two parties inside the society. But here is a problem between the person, a person, an individual, and the crown. The crown means it's like the whole society, representing the whole society. This symbol represents the whole society. In the civil law, we said it's injury, contracts matters, divorce, and contest or the will. But here, trafficking, theft, money laundering, robbery, trafficking. So all this comes in the criminal law. Killing also, or murder, this is a criminal law. Okay, when you come to compare them, here, you are the accused vs the Regina. So the Regina will be the crown approves the charges. The crown will approve the charges. But here, it is defendant and plaintiff. Defendant and plaintiff. Okay. So here, the defendant is the person who sued, and the plaintiff who will start the case. Start the case. So I'm, as example, I'm injured. I'm a plaintiff, and the defendant is the person sued. Like this is the owner of the work. The plaintiff is me. I am broken. My hand is broken. I'm called plaintiff, and the owner of the work is called defendant because I will sue him. But here, when you come to see the Regina here, the crown approves the charge, and the accused is the person charged by killing or murdering or robbing. So in the case here, the crown, but here is the plaintiff. So like the crown will represent the society is accusing the person of such things like trafficking or thefting or whatever he's having of his own. What did he do as a crime? Let us go to the nature of the decision is based on the Crown proving beyond reasonable doubt that the accused is guilty. So here we make sure that the accused, this guy, is guilty of one of those problems: theft or robbery or whatever, trafficking. Okay. But here, the decision is based on the balance of probabilities, which means that the side with the more probable evidence succeeds. So as example, which one is having proves more? Which one succeeded to convince the court that he is the right part? Okay, here the provincial court trial. Here the trials and pre-trials and conferences and pre-trial settlements. The settlement here should be in money, in a compensation. Civil law, most of the cases are just compensated by money. It's a money, like the plaintiff here, suing the owner of the work because he does not want to put him in jail, but he wants from him money. And so most of the problems of the civil law is ended with money compensation. But here, no. It is ended with almost prison. Okay. So now, here the trials, the judge alone can do in the civil law, can judge the civil law cases, judge alone, or it might be judge and jury. So the judges also might give their words to support the judge or whatever. Here it is not a pre-trial court, but here it will be the Supreme Court trial. And there will be provincial court judge, and there will be also judge or judge and jury. So because it's serious, so it needs more processes. That's I'm talking about the criminal law. It is serious, so it will need more in the process. That was about the differences. And like you see here, the decision of the court may be not guilty or guilty. Okay, so not guilty, it is like you see here, prison or fine or money or prison. When he's sentenced means he will get the accused. The accused is approved and he proved to be guilty. Then he will go to prison or pay money, dollars. Not guilty, it's okay. Then in that case is done. Case is over. But guilty, we have one of two things: bars or prison and or money. Here in the civil law, the problems will result in one of two things: liable or not liable. Liable for compensation, not liable for compensation. If he's liable for compensation, then the defendant will pay to the plaintiff amount of money. The case or the judge will be included what amount should be compensated, what is the amount of compensation should be. This is, in simple words, the differences between the civil law and the criminal law. It seems from you, in front of you, my dears, that the criminal law is more, the process are more complicated and the process is more detailed and procedures are more in the criminal law than it in the civil law. when you compare between both of them. That today, now we will go now to our own portal, and we will put lecture 2 question 1. We will work on lecture 2 question 1. See first, here we go, lecture 2 question 1. Lecture 2 question 1. Here we go. And the question will be, state the main differences between civil law and criminal law. State the main differences between civil law and criminal law. Same question will go to my dear students who do not have D2L. And just please, if you don't have D2L, send me the answer of this question, which I will write now in front of you. This question. Okay, this question. Write the answer on your own portal or your own, chat box. So write the answer of this question on the chat box. This is lecture 2, question 1. Please take it. The question, you can see it now. Start answering. See the difference between civil law and criminal law and send me the answers in the chat box. That is, if you don't have, in the case you don't have D2L working, because I know some of you are having D2L and some others they don't have. But the people who have, my dear students who have D2L, you will find a question on the D2L. Lecture 2, question 1. Shall stay here around 5 minutes to finish, from 5 to 7 minutes to finish this question. Then we will move to another thing. Thank you. You might answer. Still, the question is here also. For my dear students who don't have D2L, here is the question. Please go for answering it on Google, on the chat box. On the chat box. Again, my dears, state the main differences between civil law and criminal law. We have here about 7 minutes to finish this target. Thank you. Okay, we'll move now to the next part of our work. So sources of law. The sources of law in any society, we have the case law and we have the legislative law. We have the case law and we have the legislative law. The case law comes from the decision of previous and similar cases, also called common law. So sometimes also we call it the case law, we call it the common law. It comes from the decisions of previous and similar cases. So sometimes you see, and this is what the lawyers depend upon, they take some previous decisions of the court and they will inform the client that it will be in such a case. It's a similar to this case. The other thing is legislative law. Law that are created from municipal, provincial, territorial, and federal governments. We call it a legislative law. So we have case law and we have legislative law. Legislative law that are created from municipal, provincial, territorials, and federal governments. Cool. Here we have the system of the courts in Canada. And this is very important because here we will have a stop and check this chart. I want you to know very well the components of this chart. On the top of them, the Supreme Court of Canada comes the Supreme Court of Canada. Then we have here the Court of Appeal of a province. And we have the Federal Courts of Canada, Appeal Division, for federal courts for trial division and for tax courts. So it's the Federal Court of Canada is supervision for both these courts, tax court and federal court trial division. Those two report to the Federal Court of Canada. We have Queen's Bench of Province, we have Court Appeal of Province, and we have the provincial courts, also small claims. Those small claims go into the Court of Appeal. And also the provincial courts, also small claims, it goes to the Supreme Court instead of the Queen's Bench, to the bench, instead of the Queen's Bench, it go to the Supreme Court of Province, or it goes to the Court of Appeals of a province. So those are the system of the courts in Canada. I just want you to stand here and watch when you read the slides, watch carefully and try to remember this structure within your work so that you will know what's it. Beside the courts, we have another way to finish any disputes out of the courts itself. So we have the courts and we have another areas where we can finish the disputes out of this courts. We can finish the disputes out of this courts. So here are the example, alternative dispute resolutions. The alternative dispute, without going to courts, we sit together and finish it. We have arbitration, we have mediation. When we put third party, all this to try to solve the problems. So alternative dispute resolutions, ADR, is another way of disputes between persons and or companies to be solved. Several benefits exist for both sides in using ADR. Of course, when you use the ADR, it will help in save money, the money of the courts, the lawyers' costs and the court fees cost. You will save it because you will not go to the court. You will solve it like people, like committees or bodies or organizations will interfere to finish this problem out of the courts through the negotiation. And this, of course, is very good because this will help to save money and save time. It will save the money and save time no lengthy trial process. It will save money and save time. Creates goodwill also, preserves diplomatic relationship between the parties because they work together towards a solution. Now they are not like the court plaintiff and defendant. No, they are working together to solve the problem. So this makes a kind of good relationship between them, even though there is a conflict between them, but still they are not like enemies. So it saves money and save time, and at the same time build a good relationship between the parties of the dispute. They work together towards a solution where the sides can live with. Increase compliance. This is another point. It will increase the compliance. Compliance of what? Of the parties are more likely to comply with a mutual decision. So whatever the ADR will get to a result, it will be enforceable for both the parties to execute. Both the parties will execute it in that case. Maintain privacy. Sessions are not open to the public. Reduce stress because of reasons listed above. Once we finish the dispute, then there is no stress anymore. There will not be stress. Reduce stress because of the reasons listed above. There are several forms of ADR. The most common forms of them, we call it mediation and the arbitration. So mediation is to solve the problem, and arbitration also to solve the problems. Now, we've been talking about the Supreme Court of Canada, the first one, the Supreme Court of Canada. So here we will have some facts about the Supreme Court of Canada. What are these facts? It deals with the criminal, civil, administrative, and constitutional cases. So any cases, either criminal, administrative, or constitutional, the Supreme Court of Canada deal with them. When addressing a Supreme Court judge justice, use justice plus their last name. Okay? So you will use justice and the last name. So as example, if I am Kashwa, the last name Justice Kashwa or Mr. Justice Kashwa. In writing, the Honorable Madam or Mr. Justice. And when you write, you will say the Honorable Madam or Mr. Justice. The head of all of the judges is the Chief Justice or the Right Honorable Justice, the last name. There are 9 Supreme Courts of Canada justices. In Canada, we have 9 Supreme Courts. 3 members must be from Quebec. So out of this 9 Supreme, there are 9 Supreme Courts of Canada justices. 3 members must be from Quebec. The Supreme Court of Canada is located in Ottawa. The court hearings are open to the public. So even the court hearing in this either criminal or administrative or constitutional, it's open to the public. It's not closed. It's not private or secret one. So this was about the facts about the Supreme Courts of Canada. And let us go now. We'll have 2 questions here in this area actually. The first question is about the arbitration and we talk about the difference between civil law and criminal law. Now we will move into, and we talk about the sources of law. Now we will talk about the Supreme Court of Canada, and the ADR will have now questions about the ADR and about the Supreme Court of Canada. So we'll go now, lecture 2, question 2. State what you know about the Supreme Court, C-O-U-R-T, Court of Canada. This is the first point. State what you know about the Supreme Court of Canada. This is the first point. The second point is or the second thing question today is, or the third question, lecture 2, question 3, lecture 2, question 3 will be about the arbitration. State what you know about the arbitration. About the arbitration. And also, we need to know about the mediation. State what you know about the mediation. So state what you know about the mediation. I put all the questions together now. Those are the three questions which you have today or now in this lecture. About the Supreme Court of Canada and about the arbitration and the mediation. So also don't forget to say what are the privileges of using the other question, what are the privileges of using the mediation and arbitration, or what are the advantage? So we can say here about the arbitration and its advantage. So what are the advantages of the arbitration? We said save money, it save time, and it make a good relationship between the parties of the confusion or the conflict, and it reach to a compliance decisions regarding both the parties. Shall take these questions now and go into our own portal. We'll add those questions in our own portal right away. So here we'll go to lecture 2, question 2. Lecture 2, question 2. And here is the question will be right away. Lecture 2, question 2. Here we go to the question. Control and C. And here is our question. Lecture 2, question 3. We'll go now to lecture 2, question 3. Lecture 2, question 3. It will be about the mediation. What do we mean by the mediation? And we will no, I'm sorry about that. Control and C. Here we go, Control and V. Control and C. Control and V. And of course, the advantage of the arbitration is the same advantages like the mediation. Both are the same, that you will reach to a solution out of the costs of the courts, and it will be compliance for both the parties. And at the same time, the parts will work in a good way, in a diplomatic way. There will be no conflict between them the way it will be when there are courts or problems. The enmity between them will be less because they will sit on the table for negotiation together. And that's why it will be like this. So those are the three questions which we want to talk about. I will give here around 10 minutes to answer these questions. Then we will move to the next part. Thank you. So please, here are the questions. The Supreme Court of Canada and the arbitration and the mediation and the advantage of each one of them. If you don't have a D2L, if you don't have D2L, please work on send the answers on the chat room. We will be here like around 10 minutes for the three questions, or maybe more based on your request. I see that 10 minutes will be fine. If you want more, we can add more minutes till you finish your answer. You can also check the slides, which is uploaded here for you on the D2L, or go for the answers from searching Google. Search Google for the answer, or if you want to search other websites, you can search for more details about the Supreme Court of Canada and about the arbitration and about the mediation. Okay, we'll keep here around 10 minutes and we'll be back. Okay, that will be fine for here. Thank you so much.